Thanks very much for inviting me. So thanks to Lucina and to Kelvin for inviting me. Thanks very much to Flora for helping with the admin side. What I thought I would talk about today is I realized actually, as I was looking over my notes this morning, that it's a pretty boring title. It is essentially a few examples of where England and Wales and Australia have diverged in knowing receipt and knowing assistance. That's essentially what's going on. And I thought it might be interesting for people in Hong Kong to learn about it because, of course, you don't need me to tell you that they're two of the jurisdictions that have most of perhaps some of the largest influence on Hong Kong. And these are a couple of areas where it might be up to Hong Kong which way it decides to go. And of course, particularly with the Australian representation on the Court of Final Appeal at the moment, it might be something that comes up before the court. So hopefully it's sort of interesting, and also it might be practically relevant at some point in future. So that's the hope anyway. So first thing to note is that really I'm talking about Barnes and Addy here. One of the interesting things, in fact, is that you hardly ever see that case cited in England anymore. People just go straight to the language of knowing receipt and dishonest assistance, whereas in Australia, it's still very common to talk about first limb, second limb, Barnes and Addy. So that gives you sort of a little bit of an insight into this, which is in some ways, and the Australians would be very happy with me saying this, Australia is sort of the refuge of the pure equitable jurisprudence. And this isn't Australia doing its own thing and going away from the fatherland. This is the fatherland doing its own thing, and Australia being the refuge of the pure. Anyway, a few little amuse bouches, some pretty obvious ones. Knowing against dishonest assistance. You all know this. You know that it's still knowing assistance in Australia and it's dishonest assistance in England and Wales, and I think probably in Hong Kong now. What's interesting about that is not so much the language of knowing versus dishonest assistance. It's the fact that within knowing assistance, there is the extra requirement of a dishonest trustee. And a lot of the stuff that we'll be looking at here, what the driver is, if you like, for the developments that have happened in Australia, is that difficulty of sometimes proving a dishonest trustee breach. So it's very easy to look at the headline of the difference between knowing assistance and dishonest assistance. And once you dig down into that a little bit, you see that there's probably not an enormous amount of difference between saying that someone's knowledgeable and someone's dishonest. But the really interesting thing is that if you take the Australian approach, it's not just knowing assistance. It really is, in that traditional Barnes and Addy, knowing assistance in a dishonest and fraudulent design on the part of the trustee. And that quality of the trustee breach can be quite difficult. Another difference is knowledge after receipt. The English are pretty happy in saying that knowing receipt doesn't really matter when the knowledge comes. The knowledge can come after you've received it, as long as before you've dissipated it, and we still call that knowing receipt. In Australia, you wouldn't call that knowing receipt. They think that that's a sort of form of inconsistent dealing, or perhaps something completely separate. Again, not an enormous distinction. These are just teasers for you. Third one, account of profits from a third party. This is almost certainly an example where England has just gone wrong. You'll be aware of the case of Novoship, which says that if you are accounting, or if you're seeking an account of profits from a third party, that account is not taken in the same way as it might be taken against a wrongdoing fiduciary itself. You might be able to keep some of those accounts if you're a third party on the basis that you would have made them anyway, or they weren't the proximate cause, or whatever language you might want to choose. So the case of Novoship in England about a decade or so ago sort of changed that for calculating accounts against third parties. Whereas in Australia, we have the case called Ancient Order of Foresters against Life Plan, which makes it quite clear that actually it's essentially the same. Now, this is an example of where I think probably England's gone wrong. And in fact, Lord Briggs, in an extrajudicial paper, has suggested that he might want to have a look at Novoship again. So it might be that this distinction is not very long lived. But certainly at the moment, these are distinctions. Now, they're three little obvious divergences, not particularly important perhaps, but what I'd like to do is talk about three others that I've noticed that perhaps are a little bit more important or a little bit more fundamental. It's interesting holding the microphone. We record lectures regularly at Sydney now, and I've become very adept at turning off the microphone when I want to defame a judge, or something like that. But I'm not quite as confident as turning this one off. So I will unfortunately not be giving you the defamatory version, which is only in my notes. If I get so far, then Lucina can kick me under the table. But we'll see if we can avoid that. And actually, just on that little last point, something I noticed when I was doing some research for this is I don't think that that Nova ship point has been considered in Hong Kong yet. If it has, I've missed it. But in noticing that, I did notice an oddity about the way that knowing assistance or dishonest assistance cases are run in Hong Kong. It seems to lead back to a bit in Bullen and Leake's pleading, in that at least some Hong Kong cases have resulting in loss to the plaintiff as a sort of fourth requirement in dishonest assistance, and when the judge cites this, it's because this is in Bullen and Leake and Jacobs' pleadings. That's just simply not the law anywhere, I don't think, anymore. It's just one of the things that I noticed. I tried to sort of trace the start of this, and it turns out that that same requirement is in the English version of Bullen and Leakes, but they just don't cite that in England, but they cite the Hong Kong version in Hong Kong. And it's interesting that that means that at least some cases have gone off perhaps down the wrong track on thinking that loss is a requirement in dishonest assistance. Anyway, on to the main bits. Trust property. Now, of course, when we talk about knowing receipt, it's knowing receipt of trust property. Preliminary point is that unlike some jurisdictions, both England and Australia care very much about the receipt of property. It's not an enrichment analysis, it's a receipt of property analysis. Now, of course, very often they go together, but not always. So you see this, for example, in the Australian case of Quince and Varga, and in the English case of OJSC and Abramovich. Now, in both of these cases, knowing receipt claims failed, because although the defendant was enriched, the defendant did not receive property. So in Quince and Varga, what happened is that a man held property on trust for a client of his, and in breach of that trust, he spent a load of the trust money for his wife. Now, some of the money he simply gave to his wife. Of course, no receipt can lie there. Some of the money he used to buy things for his wife, like a fridge, no receipt there, dead easy tracing, perfectly fine. But some of the money he used to pay off debts that his wife owed. Now, the problem with that, of course, is that while economically it's precisely the same if you give her the $20,000 and she pays off the school fees, as if you simply paid off the school fees, in the second of those, you don't actually see any trust property going through the hands of the wife. So in that situation, the wife was liable for knowing receipt for the first two examples, the property given, well, the money given to her and the property bought for her, but not for the final one. OJSC Oil and Abramovich is quite a different case, but it's the same principle. In this case, Mr. Abramovich's shareholding in a company that he already owned rose in value. Now, he was enriched in that the value of his shareholding rose, but he didn't receive any property there. So even if that enrichment or that rise in value happened because of a breach of fiduciary duty by somebody else that he was cognizant of, he couldn't be liable for knowing receipt. So first point to make is that both of the jurisdictions care very much about receipt of trust property. But what about the trust bit? Now, this is, I suppose, the first substantive point. There's a case called Kupang Resources and the Commonwealth of Australia number 4, which doesn't sound like it's a particularly important case. And it may be, because it's just a trial decision, it may be I'm making too much hay out of a trial judge's decision here. But it seems to me to say a few interesting things. Now, this is an Australian case, just to be clear, from the Supreme Court of New South Wales towards the end of last year. Now, it involves a man called Mr. Grimaldi, and Grimaldi is a word or a name which, if you've sort of aware of this area, you'll have heard that name before. Mr. Grimaldi was a director of a company called Chameleon, and years ago, 20-odd years ago, he breached his fiduciary duties to Chameleon by using Chameleon's money to essentially prosecute an opportunity not for them, but for himself and another company called Murchison. And he made an awful lot of money out of this. He made profits of about $36 million. Now, of course, he was making these profits, and he was sorry, I'm trying to make two different points at the same time, which is very bad. So he made about $36 million worth of profit. Now, of course, Chameleon, the company that he did this in breach of his fiduciary duties to, Chameleon is not very happy about this. So Chameleon sue him and various other companies that are involved with him. And they seek an account of profits and various proprietary remedies against Mr. Grimaldi, and they win. They win in 2010. So the second case there is 2010. That's a decision of the Federal Court of Australia, which essentially decides that Mr. Grimaldi has breached his fiduciary duties, he's liable to account, and various other of his companies are liable to account as well. So that happens in 2010. While all this has been going on in the background, Mr. Grimaldi has been chased by the taxman. He's being chased by the Australian Taxation Office. And they get summary judgment against him for $36 million. And they eventually settle for $20 million. And he pays that settlement. He pays that settlement the day before the 2010 judgment. So what happens here is all the money that he has made through these dodgy dealings, all the money that he has made, which he is supposed to account to Chameleon for, ends up in the hands of the Taxation Office. Okay, and what this means is that when Chameleon sort of finally win, because of course there's an appeal in that one, which ends up being decided in 2012, but for our purposes, nothing changes. He's still liable to account. By the time Chameleon come to sort of collect their winnings, there's absolutely nothing left because he's given it all to the tax office. So a few years later, Chameleon changes tack, now called Coupang Resources, and sues the tax office for knowing receipt. Now, the tax office has not covered itself in glory here, right? The tax office knows full well what's going on and how this money has been made, etc. But the tax office has agreed a settlement, the terms of which are essentially, you can't break this settlement, and they've received $20 million. So the question is it possible to make the Commonwealth liable for knowing receipt? Well, again, the Commonwealth hasn't covered itself in glory here, but it's not immediately clear how it's liable in knowing receipt because, and here we see a split between England and Australia, or certainly England as it now is after cases like Recovery Partners and Hotel Portfolio. In Australia, there is no automatic rule that a fiduciary gain is held on constructive trust. Okay, if a fiduciary makes a gain in breach of fiduciary duty, then it may be that that's held on institutional constructive trust, or another judge might decide it's remedial constructive trust, or another judge might just say there's a liability to account. Okay, there is no automaticity about a proprietary response there. And in fact, more than that, in Chameleon and Murchison Metals, in the 2010 decision, the orders of the court were that Mr. Grimaldi had to account to Chameleon. There was no proprietary response there. He had to pay an amount of money to Chameleon, calculated according to the amount of the profits that he made. But that's not the same as saying that he held money on trust for Chameleon. And yet and of course we think of it as the same money, all of that money that he made, he didn't pay to Chameleon, he ended up paying to the Taxation Office. Now, this is a point where I'd really like to turn the microphone off, but maybe this is a matter for chats in the bar later on. We can edit. Anyway. No, darn it! I've misled myself again by thinking anyway. So, if you were to ask somebody in Australia before the Coupang case, how would this work with knowing receipt? We would say, well, the problem is you haven't got breach of trust property. Now, of course, trust property is not just express trusts. Of course, it's resulting trusts, constructive trusts. Of course, it's an administered estates, read Diplock. Of course, it's corporations, the most obvious thing. But I don't think anybody in Australia would have said before Coupang that trust property included property in respect of which you had a liability to account, but not property that you held on trust, right? That would seem to be a little bit of a leap there. Now, I'm not saying it's the same thing as the top one. I'm not saying it's the same as Quince and Varga, because, of course, the Taxation Office still received property. They received money. It's just that they received money where we don't see anybody else as having a prior interest in it, right? The money that they received was to be used to calculate a debt owing from Grimaldi to Chameleon. But that's a far cry from saying that Chameleon had some sort of interest in that money beforehand. Now, you could have said that. You could have said that those gains were held on constructive trust. And as Justice McGrath in Coupang accepts, in England now, that's what you would say. You would say from the moment that gain was made, it was held on constructive trust. So, of course, you can have knowing receipt. But that's simply not the way that the law works in Australia. implicit in what I've been saying is that Justice McGrath found that the Commonwealth was liable for knowing receipt. On this trust property point, the argument was made that there was no property here in respect of which there's a prior interest. So how can there be any knowing receipt? And His Honour effectively criticised counsel for saying that we were in England. We're not in England. That argument might work in England, but we're in Australia. And in Australia, the law of knowing receipt is different. Now, I'll come to a little bit later where he actually where you can see the differences between what you might call the rationales of knowing receipt in England and Australia. But first, I want to make a sort of slightly different point, which is Justice McGrath seemed to think that what was going on here was a sort of consistency of remedies point. He seemed to think that, the argument was you can only get knowing receipt against the Commonwealth if you've already got a constructive trust against Mr. Grimaldi. Now, that's right, but it's not right because of a consistency of remedies point, right? We're not saying that there has to be some sort of consistency between the relief that's ordered against one and the relief that's ordered against the other. It's a more fundamental point than that. It's recognizing that knowing receipt is, and you can use the word parasitic, ancillary, whatever you might want to do. One of the building blocks of knowing receipt is a breach of trust by somebody else, right? Now, that breach of trust is wider than just an express trust, and it's wider than a trust properly so called. As we know, it includes corporations, it includes ministers and the Crown, a number of Caribbean cases in that respect. But in all of those situations, there is some sort of interest that the claimant has, right? So it's not a consistency of remedies point. It's a sort of hierarchy point. You can only be liable if there is a breach of trust and fiduciary duty by somebody else. And it's only if that property is misapplied. You can't just say this person's a wrongdoing fiduciary and here's some money, therefore I get it. So look at what he says here. Any suggestion that there must be some coincidence or contingency in the remedy awarded against an errant fiduciary and a knowing recipient cannot be good as a matter of law. Applying common sense, and we all know it's wonderful when judges say things like that, applying common sense, the utility of proprietary remedies against a fiduciary who has passed trust property to a recipient is doubtful. So too is the suggestion that the availability of such a remedy against a recipient is somehow contingent on the same remedy having been awarded against the errant fiduciary. It's not about consistency of remedies. It's about recognizing that one of the building blocks of the claim against the third party is a breach by somebody else. That's not an English-Australian thing. That's I think common to everybody. And just to skip to the bottom of the last one, whether or not a remedial constructive trust over those profits was ultimately ordered as part of the initial litigation is entirely beside the point. Well, with respect, Your Honour, it's not entirely beside the point. It is the point, right? At least if knowing receipt is to be understood as transferring property in breach of trust. It is entirely the point. Okay. Another interesting point in Kupang Resources is that His Honour goes even further than this, and this may be particularly, I think, surprising. And one of the arguments made in the case was that, in fact, the Commonwealth could not be liable for knowing receipt because the money had passed through the hands of a bona fide purchaser for value without notice. Now, the reasons why that argument was made are quite technical, and it essentially involves the money was paid to the New South Wales Treasury before it was paid to the Commonwealth. And the argument was that the New South Wales Treasury was a bona fide purchaser of the money. His Honour found that it wasn't for unimpeachable reasons. But His Honour did go a little bit further than that and said, well, even if it was a bona fide purchaser, I don't think that would stop the claim against the third party. Now, this would seem to be really quite radical, because whether you think that it's about a continuing equitable proprietary interest or a continuing right to due administration, as Professor Home, Professor Mitchell might argue, whatever you think is there, whatever that sort of kernel that the claimant has to have, it's going to be cut off by a transfer to a bona fide purchaser. And this would be a really quite, I think, surprising development. Now, it must be accepted this is only obiter dicta because His Honour found that it wasn't a bona fide purchaser, but he did deal with the point quite substantially. And we all think, well, this is mad. How if it goes through the hands of a bona fide purchaser, how can that still ground knowing receipt? Well, of course, it's because it's just a different way of looking at it in Australia. So this is the appeal of the initial Grimaldi litigation. As I'm sure many of you know, this was Justice Paul Finn's sort of, magnum opus at the end of his career, where he wrote this absolutely magisterial disquisition on Barnes and Addy and fiduciary liability more generally. And one of the comments that he made in that is that liability, i.e. knowing receipt, arises as a matter of conscience, not of property. Now, arguably, he made that point in quite a specific context, and it's been taken out of that context. But that passage has been cited many, many times to show that it's not about a proprietary claim plus. Knowing receipt is not the extra bit that you get on top of the proprietary claim. Knowing receipt is a separate form of liability, and it may not require a continuing proprietary interest in the way that the English authorities now suggest. Now, compare that to the most recent explanation of it in England by Lord Briggs in Byers. And Lord Briggs clearly sees this as the extra bit that you get on top of the proprietary claim. Now, that's not to say that the property has to have been dissipated, because it doesn't. Akita, for example, in the Turks and Caicos Islands, Privy Council said you can have knowing receipt when the property is still there. But it is to say, as we all know, that knowing receipt is most valuable when you can't make the property claim anymore. So there's just very, very different ways of looking at it. I think the way I've sort of would put this is, I think the English say that although you don't have to be able to make the proprietary claim now to get knowing receipt, you have to have been able to make the proprietary claim at some point. If you saw it quickly enough, if you got to the court quickly enough, you have to have been able at one point to make the proprietary claim if you're going to make a knowing receipt on claim on top of it. That's just simply not the position in Australia. And even outside Kupang, there's various cases that involve torrens and divisibility of land and things like that, which say the same thing, which say that there's no requirement that you ever be able to make a proprietary claim in order for you to be able to make the knowing receipt claim. So that, I think, is the first distinction that I wanted to sort of drill into a little bit. It's a first instance decision, although it's extremely scholarly first instance decision. It may be overturned on appeal, who knows? But even if it is, certainly the different casts of mind, the points that are up on the screen now, are going to survive just as different emphases on the way that this situation works. Now, the next point, you see that this is Grimaldian corporate alter ego liability. This is something I've written on a little bit more at length, and this is the idea in Australia that there is a separate form of liability that exists alongside knowing receipt and knowing assistance and applies only to companies. And not just only companies, only small one-person companies, creature companies, cat's paw companies, alter egos for that matter. And the idea here is that outside knowing receipt and knowing assistance, you can make those companies liable simply on a sort of short-circuited alter ego basis. Now, I haven't got time in this meeting to talk about the sort of great ins and outs of that, but it came from this case called Grimaldi. And I won't read all that out to you, but this is the starting point, the fons et origo, if you like, of corporate alter ego liability. Now, in an article a couple of years ago, Khalida Tang and I wrote and sort of criticized the basics for this. And I think, frankly, Justice Finn, I think, has just made it up, right? But if you're Justice Finn, you can make things up, and people think that it's the law. So this has actually now been applied in Australia in several subsequent cases. Now, I don't want to overstate the point. It's not all corporations. It's only corporations that can be considered alter egos. So you know the situation, mum and dad company, they're the only shareholders and directors, that kind of thing, right? But it matters. And it's not just that it matters because it is a short circuit version of knowing receipt. There are some cases after Grimaldi which actually indicate liability that would not have been possible under Barnes and Addy, or that would have a different result under Barnes and Addy. So to give you some examples of this. So Mudgee, Dolomite, and Lime and Murdoch. Now, just in case you didn't know, as I'm sure you all did, limestone is calcium carbonate. I'm sure you all knew that. You might not have known that dolomite is calcium magnesium carbonate. So there you are. But it's worth getting into this industry if you can. There is an awful lot of money in this industry. Now, what happened in this case was Mudgee Dolomite and Lime Proprietary Limited was a very large company, or is a very large company that owns a number of mines in New South Wales. And two of the directors of that company, two people called Mr. Murdoch, they essentially took an opportunity, or took several opportunities, that they should have prosecuted for Mudgee Dolomite and Lime, and they instead exploited those opportunities through their own creature companies, through companies that they were the only shareholder and director of, that sort of thing. So it's a story as old as the hills. It's misdirecting a corporate opportunity from the company you should have exploited it for to your own personal company. Now, the interesting thing here was, because it's misdirecting a corporate opportunity, you can't claim knowing receipt. You could claim knowing assistance, perhaps, but the problem with knowing assistance is you have to prove a dishonest and fraudulent breach. And that can be a difficult thing. I shouldn't say difficult. It can be something which is quite often forgotten to plead. The number of cases where people forget to plead in terms dishonesty on the part of the trustee, and that's where it all falls down, is actually quite surprising. So in some ways, it's not even that intellectually you have to get a dishonest trustee. It's that you have to remember to distinctly plead the dishonesty of the trustee. So in this case, there was no liability in knowing assistance because it wasn't argued, and there was no liability in knowing receipt because there was no receipt of trust property. But Justice Black, the judge, still found those companies liable on the alter ego basis. And that's an interesting thing there, because it's an example of liability being found when it couldn't be grounded on knowing receipt or knowing assistance, because no trust property, and in the assistance case, it simply wasn't argued. But there's a number of other situations like that. So it's not just a sort of intellectual, interesting thing. It's actually leading to outcomes that would not be possible under more traditional Barnes and Addy liability. Another one is Zabara and Ultra Management. Again, a very common story here. Two sports agents who worked for a company called Ultra Management had had enough of working for Ultra Management and wanted to set up on their own. So they took a load of National Rugby League stars with them to a new company called Genesis. And Mr. Zabara and Mr. Angeli were the wrongdoing fiduciaries, and they took these clients of Ultra Management to their new company called Genesis. Now, Genesis, at first instance, was found liable for knowing assistance. On appeal, the point was made that, but you haven't pleaded dishonesty against the trustees. So you have to plead dishonesty against the trustees, even if you're suing the third parties, right? And the point was made, well, look, we don't think you've pleaded this properly, so you're going to have to vacate the decision. Now, the full federal court, by majority, said actually the dishonesty of the trustees, the dishonesty of the fiduciaries had been sufficiently pleaded. So the finding of knowing assistance against the corporation could stand. But interestingly, they said, and even if it hadn't been properly pleaded, we could still have found them liable on the alter ego basis. So again, you would have had then a situation where you couldn't have had knowing receipt because no property. And what the full federal court is saying, at least by majority, is that you could have liability that was not knowing assistance. Now, in fact, one of the judges, the minority judge, Justice Derrington, very powerful dissent, just going through saying, I don't agree with this. I don't think this corporate alter ego liability exists. I don't think we need it. I don't think it should exist. But he's one and the other two are two. This, I didn't realize, I wouldn't normally put this one in here, but apparently the baby milk market in mainland China is absolutely enormous. And what I didn't realize was quite how valuable Australian cows are, and also how much more valuable than New Zealand cows they are, because this was all about a company that manufactured baby milk and for the Chinese market. There was a sort of an internecine dispute. Somebody else went off, used the same corporate name, but their baby milk came from New Zealand cows, and this could not be borne. So anyway, I try and make a joke about tracing because that's traceability. It's nothing to do with traceability, but you will see that the Australian flag is on the top there, and that's not just randomly on the top. That is to show how poor New Zealand cows are. Now, what happened here? This is summary proceedings. Okay, this is freezing injunction proceedings, well before the actual litigation. But what Justice Black, who you'll notice is the judge who did the Mudgee Dolomite and Lime case, he extended a freezing injunction against two companies to essentially all the assets of those companies, which was a greater amount than they could ever possibly have been seen to have actually received from this breach of fiduciary duty. So I'm not explaining that very well, but what he essentially did was say, if I can make a freezing order against the humans, Mr. He and Miss Liu, then I can expand that freezing injunction to cover all of the assets of their creature companies. And I don't have to worry that those creature companies at most would be liable for a lesser amount on knowing receipt or knowing assistance. So the idea being that they could be liable for the whole amount that the fiduciaries are liable for on this corporate alter ego analysis. Now, it's a first instance decision. It's not even sort of following a full trial, but you can see from the year, these are all fairly recent. This is a developing area of law, and it's something that at some point, somebody I think in Hong Kong is going to try and argue in Hong Kong as well. More recently, I will skip over this because I want to get to my final point. More recently, the corporate alter ego analysis has also been applied in a case only a couple of months ago, Wright Prospect and Hancock Prospecting, which is about Gina Rinehart. You've probably heard of Australia's richest woman. And perhaps most importantly, the idea that this liability exists has been given the imprimatur of 3 members of the High Court in a case called Neyman and Jakin. Now, Neyman and Jakin is a case about trustee liens and fiduciary duties. It's not a case about this particular point. And the 3 judges who are mentioned there are in dissent. But they've mentioned in the High Court that this form of corporate alter ego liability exists. And I hope I've sort of explained to you that it's not just knowing receipt or knowing assistance in different words. It actually has some different, or potentially some different effects. And the reason why that's particularly interesting in this context as well is that seems to be very much against the Preston Petrodel or Lifestyle and Ahmed, the sort of the view that the superior English courts are taking at the moment. So last point, which I will try and get through as quickly as possible because I can see that I don't have that long left, is joint and several liability and release. I'm going to run these 2 points together. So the first point is about joint and several liability between a fiduciary and accessories. Now, it is incredibly common to find comments to the effect that liability of fiduciaries and accessories is joint and several. One place where you can find such a bold and misleading comment is in the latest edition of Hambry and Martin. In a paragraph that I wrote, and I therefore can't even blame my colleague James Lee for doing this. And I happily wrote that liability is joint and several. And more recently, I've realized that is rather misleading. So first, let's unpack a few things. To the extent that you're talking about the calculation of liability, then joint and several liability is a fair enough thing to say. Everybody knows that throughout the common law world, with the possible exception of Canada, profit-based liability is several. You're liable for your own profits. But loss-based liability is joint and several in the sense that an accessory is liable for the consequences of the breach in which they assist, not liable for the consequences of their assistance. It's worth just saying that again, okay? And Paul Davies somewhere will be disagreeing with me. But if you are a knowing assistant and you assist in a breach of fiduciary duty, you are then liable for the consequences of that breach of fiduciary duty. You don't get to say that your assistance was hardly causative or, whatever it might be. The basic structure of liability is that once you are a knowing assistant, and of course that requires a lot of analysis of at what stage did you help, etc. Once you are a knowing assistant or a dishonest assistant, you are liable for the consequences of the fiduciary breach. You're not liable for the consequences of your assistance, okay? Now that I think is fairly clear. There's a lot of cases that back that up, including some very recent cases. But joint and several is used in another sense as well. It's also used in the sense of release. If you release one party from liability, does that have the effect of releasing the other parties from liability? So if you settle with the trustee, does that mean that you've also decided not to pursue any claims against the assistants? Now, historically, at common law, if you released one person who had a joint obligation, that released the other. That makes sense. We're talking about joint obligations. But that rule was also extended to joint and several obligations, where perhaps it makes slightly less sense. But that was the position. And in an Australian case of a few years ago, a release was granted against a dishonest assistant, or knowing assistant, I should say. And the judge said, well, that means you've released the fiduciary as well, because it's joint and several liability. So if you've released somebody who is jointly and severally liable, you've released the other one as well. Now, it was by accident, of course, but you've done it by accident. This then came to a head in a case called Casaniti and Ball, where the Court of Appeal of New South Wales took a different view. The Court of Appeal of New South Wales decided that, in fact, first thing they said is that the language of joint and several doesn't really apply very well to trustees and accessories. It's a common law language that just doesn't really work here for reasons that I'm afraid we probably don't have time to talk about. They said that as a matter of statutory interpretation, that release rule, that idea that if you release one jointly and severally liable person, the others are released, that's been abrogated by statute. And there's quite an interesting Hong Kong point here. So the statute, the sort of first statute in this area was an English statute, the Law Reform Married Women and Tortfeasors Act, which provides that, and this at the moment it's only about tortfeasors, but it provides that a judgment recovered against any tortfeasor will not be a bar to an action against a concurrently liable tortfeasor. Now, more recently in Australia, that's been extended to not just tortfeasors, but people who are liable for the same damage. But it's still in Australia just simply refers to a judgment. So to bring yourself within this, it has to be a judgment that you've obtained against one liable party, not a compromise, not a settlement, not a release. It has to be a judgment that you've obtained. Now, in the case of Casaniti and Ball, the Court of Appeal did sort of two parts of legislative interpretation. They said that, well, first, the modern legislation, which doesn't just talk about tortfeasors, talks about liable in respect of the same harm. So that covers the knowing assistant and fiduciary situation. But the greater leap was to say that it's not just about judgments. It also includes compromises. It also includes settlements. So even though the legislation only says that a judgment against one doesn't stop you going against the other, the Court of Appeal said, well, if they've split up the judgment point, then sort of intellectually they must have done the same thing for compromises as well. Now we'll come back to that, but that's what Casaniti said. Interestingly, that is not the position in England. The position in England, which has relevantly the same legislation, is that no, this release rule only applies to judgments. It's only if you actually get a judgment against one party that you release. Sorry, it's only if you get a judgment against one party that another is not released. But the idea is that if you settle with a wrongdoing trustee and an accessory is jointly liable, then the accessory has been released as well. So it's interesting that if you can, again, in the interest of time, I won't read them both out, but you can look at the different approach between the High Court of Australia and the first one, and the Court of Appeal of England and Wales, and not just any Court of Appeal, but Lord Briggs now, simply saying, well, it's a very different approach. When I was looking at this is my last point, I thought, well, what does Hong Kong say about this? And hopefully you all already know this, that Hong Kong is in fact ahead of everybody else, because in Hong Kong, the Civil Liability Contribution Ordinance actually provides that not only will a judgment against one not debar you from pursuing against the other, but it explicitly provides that a settlement or a release against one will not prevent you from suing the other. Now, there are a couple of situations where Hong Kong judges don't seem to have realized this, because people have tried to make this as a defense, and they haven't allowed the defense, but they haven't simply said, well, Section 7 means that you can't run the defense. So the position in Hong Kong seems to be that if you settle with the trustee, you can still pursue the assistance. That seems to be the position. That's also the position in Australia. That's not the position in England and Wales. Now, I just want to leave you with this point. I'm not sure about that, because it seems to me that this isn't just you have two claims. To go back to a point that we were making at the start, one claim is dependent on the other one. right? This is not just that there was a breach of fiduciary duty at some point in the past, right? Your liability, the liability of the accessory, is dependent on there being a breach of trust or fiduciary duty. So if that is accepted, or now maybe the difference here is between compromising and settling and acquiescing and affirming on the other. Maybe that's where the difference is. But it seems to me to be a little bit difficult to say that I'm happy with the trustee's performance, but I'm still going to say that it was wrongful for the purposes of going after an accessory. That seems difficult to me. And as I say, maybe it's the difference between settling, which is not necessarily to be interpreted as accepting or acquiescing or affirming. Maybe that's where the line is. But that's where I find it to be difficult. So that last one was a pretty technical one, but I did think it might be of particular interest to Hong Kong people, because as I said, there's been a number of cases where people have tried to make that defense that, well, I am released because this other person was released, and nobody has seemed to make that point. But if that is because people in Hong Kong prefer cases to statutes, then I am entirely on board with that. Anybody who works in universities will have had judges telling them for the last 20 years that you have to teach statutory interpretation, but we don't like statutes. They are nowhere near as interesting as cases. So I hope that is the reason. Anyway, thank you for your attention. That was all I was going to say.